And we are back on the record in cause number 2020-0D06122, State of Texas versus Bill and Andrew Rivera. We took a quick break, Mr. Rivera, just to make sure if you had any questions, your attorney could give you a little more direction. Are you ready to resume your plea?
Yes.
Okay, so I just want to go back to the actual pleas to make sure. You had previously entered guilty pleas on both counts, count 1, aggravated assault with a deadly weapon, and count 2, criminal mischief. Has that changed, or are you maintaining those are your pleas?
I'm maintaining.
Okay, so guilty pleas on both of those. If not previously found, I will find they were being made freely and voluntarily. The state summarized the plea agreement. Were you able to clarify with your attorney, Mr. Rivera, what the plea agreement was, and is that your understanding? The 7 deferred and the 2 straight?
Yes.
Okay. Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. Is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Rivera, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes.
It was signed by the court and signed by your attorney as well. Finally, as to count 1, because it is deferred, there is a motion for deferred adjudication. Appears to have your signature. Mr. Rivera, did you review that with your attorney and sign it?
Yes.
Mr. Mesa, have you explained to your client both benefits and detriments of deferred adjudication?
We did, Judge.
Mr. Rivera, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for that offense?
Yes.
And are you asking the court to grant you deferred adjudication?
Yes, ma'am.
Okay. I will find there is sufficient evidence as to count 1 to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication on count 1 pursuant to the plea agreement for a period of 7 years. I don't know if I might have said 10 years earlier. It is 7 years. That's the agreement. Now, in count 2, on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. Find you guilty of the state jail felony offense of criminal mischief in an amount between $2,500 and $30,000, and I will sentence you there according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice State Jail Facility, suspended for a period of 2 years of community supervision. There will be, as to count 1, a deadly weapon finding. Court costs, you were to possess no weapons, curfew, anger management, screen for TAP, 200 hours of community service. There is a $4,000 fine, $3,500 of that is probated, which means, Mr. Rivera, the portion that is probated, you are not going to be owing unless you fall out of compliance with probation. Then they can come after the entirety of the fine. Obviously, these run concurrent with one another. Anything further, Mr. Mesa or Ms. King?
Nothing further from the state, Your Honor.
Nothing further, Judge.
Okay, I didn't see any no contact on the ag assault deadly weapon. Did I miss that, Ms. King? Was that part of the plea paperwork?
It was on there, Your Honor. It says no contact with the complaining witness. I believe it's the second line on the.
Yes, no contact with the complainant. Okay, so that's an additional condition. Anything else? I'm sorry, Mr. Mesa, we good?
We're good, Judge. Nothing.